Hello, hello, hello. This is Attorney Mike Graham coming to you from an undisclosed location. I got a bunch of clips. A lot of it's Alyssa's fault and Zach's fault over at Leonard's Unite. Let's get this thing started. It looks pretty good. I've been told I need some sunglasses and a gold chain to complete this ensemble. I may go full Ollie G at some point. I don't know. Let's do this.
A citation. It was issued on April 25th of this year on 30th Street there in Salem Township. It's a speeding citation on an actual 72 and a 55. However, the ticket was only written as a 1 to 5 over. So, Ms. Pierre, you are here on this 1 to 5 over speeding ticket to do one of three things. First is you could admit responsibility to the citation. Or two, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened. Or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
Fight the ticket, please.
All right. Then the first thing I'm going to do is swear you both in. You want to go ahead and raise your right hands. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
I do.
Ma'am, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued a citation in the first place. But then after that, you'll have an opportunity.
Oh, this is fun. This is fun. Judge Norbeck just he can't even deal with it. It's really interesting to see.
Opportunity to either ask questions or testify in your own behalf. All right.
Okay.
And with that, deputy, if you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation.
All right. On April 25th, approximately 1:30 p.m., I was sitting southbound on 30th Street, just south of 140th Avenue, on the side of the road running stationary radar to northbound traffic. I observed a gray Ford pickup traveling northbound at speeds higher than allowed speeds. I activated my stationary radar. Upon immediate reading, I had 72 miles per hour. As the vehicle approached, I locked in at 69 miles per hour for equal tracking with no interference. The time the vehicle passed me doing 65 miles per hour, where she acknowledged my presence, I activated my emergency lights to make contact. The vehicle came to a stop just south of 140th Avenue on 30th Street. Upon contact, I advised on the reason of the traffic stop being 72 miles per hour and asked what the hurry was. I believe she stated that she was taking her son to work, and I asked her how fast she believed she was going. She stated 65 miles per hour. She was very reasonable and polite. I ended up writing the citation for 1 to 5 over.
Oh, thank you.
And that's where I left contact with Lisa.
Okay. Ma'am, what is it you'd like to tell me?
Yes, sir. I haven't had a speeding ticket in I think 15 years, and it's because I used my cruise control. And I
tell us more.
Have something wrong with my cruise control button, but I didn't know that until that day. I haven't been having issues with it.
Okay. So
I
you
was
have a
actually
speeding ticket here for going 1 to 5 over, and you're contesting that. So would you like to tell me how fast you were going that wasn't speeding?
I didn't realize that I was speeding because I was hitting my button, but it wasn't working, sir.
All right. So what do you think you had your cruise set at? How fast did you think you were going?
A, I don't believe it, but B, you shouldn't be hitting your button while you're driving there.
I thought I was going about 57, which is what I normally set it at.
Nobody who drives thinks that 57 miles an hour and 72 miles an hour feel the same, ma'am. I find that disingenuous. Why, if you set your cruise at 57, would you tell the officer you thought you were going 65? Why wouldn't you tell him I thought I was going 57 because that's what my cruise is set at?
Well, first of all, I have memory problems and I'm being
Oh.
sued for that right now. So I apologize for whatever conversation I had with him. I can't even recall my conversation. I do remember.
You see, Judge, I've got a broken cruise control and some IBS. So can we just forget this happened?
Were you taking your son to
approached
work
me
that
on
day?
the opposite side of my vehicle. I was taking a friend to work. My son happened to be in the vehicle with me.
Okay. So ma'am, how fast do you want to tell me you were going? If you're saying 57, guess what? That's 1 to 5 miles over the speed limit, right? So
I
even
was
by
going-
your own
I think-
testimony, you're admitting to the ticket you have.
I think I was going 65 miles an hour, but I was trying to stop my cruise control and it wasn't.
Okay, ma'am, if you're,
That's
okay, listen up. So here's what we have. Speed limit's 55, right? Now the deputy already testified he's got you at 72, right? But he didn't write you a ticket for that.
okay.
And then you're saying, okay, yeah, I think I was maybe going 65. Both of those are just way over the ticket you have. But even now when you're in court and you say to me, oh, I think I was only supposed to be going 57 because that.
I like Norbeck here. Usually he just ignores it all, but today he's like, this is so bad. We need to break this down point by point. The level of stupidity here. You admitted to the amount of the ticket while you said you were trying to set your cruise control at the amount of the ticket, then admitted to going faster than the amount of the ticket. And then the officer says you're going faster than that, which, by the way, we believe. Then you say you're going to contest this. Okay.
That's what I set my cruise at, but I don't really remember real well. That's exactly the ticket you have, going 1 to 5 over the speed limit, right?
Yes, sir.
So even at the very least, you're responsible for this citation. You're really probably responsible for an even bigger citation, but the deputy used his discretion and didn't write you for that. I just want to make sure we're all on the same page. I want to make sure I'm hearing you properly.
Okay.
All right. But so now you maybe don't think that you probably think you were going at least 65.
I think that I was accelerating and my cruise wasn't working.
Okay, so do you think you were speeding or not speeding? If the speed limit was 55.
Oh, sweet Jesus. I don't think she understands the words that she's saying. He said, okay, you've offered there are 3 speeds on the table, all of which are over. And her response is, well, I think I was accelerating. Okay, so we set a baseline that you're over, and now you're saying you're speeding up. Where's your defense here?
I'm just curious what you'll tell me at this point.
I love that. I love that. This is over. You're guilty. I mean, we're talking about a speeding ticket, but you've done lost. But I've got 30 seconds. I want to know what more you're going to say.
I can tell you this. I honestly thought that if by seeing you, that you would be able to either reduce my ticket to something else or give me an option to take a class or something.
Okay, ma'am. So if the testimony is by the deputy who radared you, you're going 72. What is the break you thought that I would give you?
Well, just what I asked you, sir. If there was a class or something that you could give me.
I want to dumber down the ticket. Like I want to fight that.
So I don't have any points on my license.
Then why didn't you come here and say, oh, okay, I was probably speeding, but is there anything I can do about the points? What you said is, I'm going to contest this. I don't think I should have got a speeding ticket. The
Because
deputy
I don't
already, and I explained to you very carefully when we started, you have a ticket, you were going 72 and a 55 is what the citation says. But the deputy already used his discretion and only wrote you a ticket for going 1 to 5 over. So you were accused of going 56, 57, 58, 59, or 60 miles an hour. And you said, I want to fight that. I don't think I was doing that. Right?
Yes, sir.
Okay. But I would find you responsible on the citation that's written. You do have a right to appeal that finding if you disagree with it. To appeal this to the district court with the prosecutor's office, you must do two things. One is you must ask for that within 7 days of today's date. Your window of opportunity closes after 7 days. And two, you must come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. You understand your rights on appeal?
Yes, sir.
Okay, then we're all set here. I'm going to go ahead and release parties. Thank you.
Thank you, Your Honor.
14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. Please make sure your devices are muted until your case is called. Once your case is called, please unmute your device and state your name after the attorneys have placed their appearances on the record. The
Oh,
court will
good
call the
Lord.
case of Ypsilanti Township versus Jameson Mitchell, case number 25T00181.
Paul Barnett on behalf of the township.
Good morning, Your Honor. This is Matthew Mansour, Assistant Public Defender. I am here with and on behalf of Mr. Jameson Mitchell, who appears via Zoom from the Washtenaw County Jail. Mr. Mitchell, can you state your name for the judge, please?
I look like my attorney. Jameson
Yeah.
Mitchell. You don't look like my attorney.
Yeah, it's okay. We work in the same office.
But yeah, Jameson Mitchell.
Thank you. All right, today is the day and time scheduled for a pretrial in this particular matter.
Yes, Your Honor, that is correct. To my understanding, Mr. Mitchell wants to set this for final settlement conference. Is that correct, Mr. Mitchell?
Yep.
Mhm.
And Your Honor, Mr. Lebo would like me to address bond for Mr. Mitchell whenever you are ready.
He has a PR bond, $20,000 PR with a GPS tether. What's the
Correct.
latest?
Yeah, it was just a quick modification if the court would consider.
What
Apparently, the complaining witness and Mr. Mitchell live very close to each other, I believe, across the street. The complaining witness appears to live on lot 33 on 2580. So if the court would incline removing the tether and just allowing a no-go to, since they are so close in vicinity.
Mr. Barnett?
I mean, I'm not sure why that really matters. I mean, I'm not real comfortable with agreeing to removing the tether, especially, I mean, he's on a PR bond.
Can I say something?
That's up to you, your attorney, sir.
No, Mr. Mitchell. I mean, unless you want to talk about it in another breakout room, but is that the request you were trying to make? You wanted to be off
Yeah,
the
that's the
tether?
request I'm trying to make.
Okay, then they heard it and they don't want to do it.
Well, do you want to talk to Mr. Mansour more about this?
Uh,
Mr. Mitchell,
Yeah,
you mean yes?
no, I'm good.
Yep.
Y'all trying to keep me on tether though? That's crazy though. It's crazy.
All right.
We gonna see though at trial, I guess.
I'm sorry, what did you say, sir?
Said I would rather not be on tether.
I
Right.
heard that part of the request. I asked you a simple question as to whether you
I
wanted to.
said no.
Did you just interrupt me when I was talking?
I said no.
Sir, do you want to be held in contempt of court this morning? Defendant's motion for the removal of the tether is absolutely denied. Final settlement conference in this particular case will be scheduled for June 27th, 2025 at 9:30 a.m. Jury selection will be scheduled for July 11th, 2025 at 8:30 a.m. Bond is continued.
Ms. Arnold, are you ready to go?
I am, yes.
Mr. Vincent, do you want to call the case? Mr. Vincent, you're muted. There's Mr. Vincent.
Thank you. For purposes of arraignment today, this is Terrence Ray, cause number 25L 4032. Mr. Ray has several other matters. He has a pre-trial 25L 0965, 25L 0045, 25L 0306, 25S 0016, and then two review matters, 24L 1764 and 24L 1704.
Okay. Ms. Arnold, let's, I guess, start on the arraignment.
Yes. So he has one charge for criminal trespass in the first degree, and that is on for arraignment. So defense today will waive a formal reading of the criminal complaint, ask the court to enter a plea of not guilty, and stipulate to probable cause for today's purposes only. We've been appointed on his previous matters, and his financial situation hasn't changed. So we're asking for appointment on this new charge and that all of them track along together.
Perfect. So I will enter a plea of not guilty on his behalf. I'll find probable cause based on the stipulation, and then I will appoint based on the lack of change in his financial situation, the previous finding of indigency. Mr. Vincent, what are you asking for conditions of release?
Your Honor, the city is asking for $10,000 cash or bond. The basis for that is that since let's see, October of last year, 2024, the defendant has pled guilty to crim trespass, or has a guilty to a crim trespass and a separate cause number. He was found guilty of obstructing a law enforcement officer. And then a couple weeks later, there was a new charge of a malicious mischief that is that the defendant's pled guilty to. This pattern has continued. In January of this year, the defendant was charged of crim trespass in the first degree, assault in the fourth degree, hit and run, and then almost exactly 1 month later, the defendant was charged again with criminal trespass in the first degree. In April 15th, the defendant was charged, and this is all in the city of Lakewood. The defendant was charged with criminal trespass in the second degree. 1 month later, to the day, May 15th is what he's being arraigned for now, the DUI and controlled substance possession. That was on May 15th. And then on May 20th.
Don't worry. He talks before this is over.
21st, a week later, the defendant
defendant will clear all this up.
A new charge of criminal trespass in the first degree. And I apologize. And that is what he's being arraigned on today.
Okay. Okay, Ms. Arnold, I'm sure you've noticed I sort of like consistency, and many of your clients have been released today because they were fortunate enough to have a little bit of criminal history, but it was starting to get old. I'm hearing the criminal history on this case, and it's sounding like it's all very fresh and all in Lakewood.
I apologize. I forgot to note that there were, like, um, 15 to 20 warrants that have been noted in the past as well. And there is, other assault charges, felony convictions. I didn't, felony convictions for theft, controlled substance, harassment. I didn't give the full litany of everything. I was just primarily focused with the little bit of the significant concern is the past few months.
Understood, Mr. Benson. So, Ms. Arnold, Mr. Benson, did you have a proposed bail amount?
$10,000 cash or bond.
Okay. Ms. Arnold?
Yes, Your Honor, I apologize. After realizing one thing, I'm going to request a breakout room with my client for 2 minutes, not even,
Okay.
just to get some clarity.
Okay, take your time.
Thank you.
Trespass. I didn't look that up.
Excuse me,
Oh, she tried.
officer. Officer. Officer.
Notice the nail polish. I've only seen 4 or 5 cases where guys have nail polish on, and every one of them was absolutely insane. This guy's no exception.
You going to break up room?
Okay, we're back on the record. Ms. Arnold, Mr. Vincent was asking for $10,000 in bail, had listed a litany of criminal history and a litany of warrants. I was going to ask you to respond. You wanted to have a quick breakout with your client. What do you have to tell me?
Yes, Your Honor. So there's no doubt that there's a lot going on here, as you know, everyone can see. But defense would really like the court to take into consideration that he needs to get some help for mental health purposes. He has a bed date at Prosperity Wellness, and that is reporting there tomorrow at 11 a.m. His parents are involved in helping him as well take care of himself. And so we're going to ask that he be released tonight. So he's able to attend that tomorrow in hopes that it puts him on a better track and there's no more charges that are picked up in the meantime.
Okay. I'm going to impose the $10,000 bail, Ms. Arnold. Do you want me to set this for tomorrow for court? He's got a lot going on, so I'm not sure that helps you, but I want to give you that opportunity.
Your Honor, if we could set it for Wednesday.
Okay. Is your client trying to communicate with us or is he just upset?
That I'm not sure of. I was looking at something else. Mr. Ray, do you need to speak with me or are you just upset? I guess he's muted.
He's muted.
Mr. Ray, can you unmute yourself?
Here we go.
It looks like he's trying to get help from the officer.
I promise you will learn nothing. The attorney, having just talked to him, looks very excited for this event.
Can you unmute me?
Okay, Mr. Ray, we can hear you.
Okay, now listen. Speaking for myself, it's been. I know it looks like I've been to property a lot of ups and downs with this situation.
Ray.
Mr. Ray, stop and listen to your attorney.
So I want you to know that everything that you say on the record can be used against you. And I also want to let you know that the judge has already ruled on this, okay?
No, that's what I'm saying. But moving on that, I have to. I'm being asked for to get this bed day. It's gonna help me, and it's hard for me to do. Make me focus. Like that part, I really want you to understand, Judge. Being out for this bed day is gonna help me change my life around, and it was hard for me to get. And with that being said, being released and going into for being released, mom taking to the hospital doing medication, and then next day to prosperity, it's gonna be a turnaround for me. So I please ask you, because I beg you, it's been hard. I've been hard, I've bumped my head, making wrong, you know what I'm saying, wrong place at the wrong time. And
Okay, Mr. Ray,
so, let me please, Judge,
I'd
please.
like you to watch what you're saying, okay? I understand, I
Okay,
understand the first part.
Mr. Ray, I've heard,
Okay. I'm sorry.
hold on. Mr. Ray, I've heard you. I've made my ruling. I'm imposing $10,000 bail. The court date next Wednesday.
But see, that fails me. I'm trying to help myself, though, Your Honor. Like, I've been trying to help myself.
Mr. Ray, that is all. He made his ruling, so there's no debate moving forward, okay?
No sympathy about that's not going to help my situation. I'm going to be in a worse situation. I said it was something to help me. Yeah, I said something to help me.
No, Mr. Ray, Ray, I made my decision. What time is the court hearing on Wednesday?
It is at 11 a.m.
We made a decision that's not going to
Okay, Mr. Ray, you will have court Wednesday at 11 a.m. I'm going to impose standard conditions of release. Is there anything else we need to do on this case?
No, Your Honor.
No, Your Honor. Thank you.
Okay, perfect. Then that'll be the ruling of the court, and we will sign that order in about an hour.
Okay.
And then we'll set all the other dates tracking on that date as well.
Thank you.
Your Honor,
Okay, fantastic.
I noted as released on all of the counts except for the arraignment and put the bail under the arraignment matter. And I put an out of custody date
That's perfect.
if he is released for June 10th at 2 p.m. Is there a different date that you would like, or?
No, I think that's a great date. We'll set the June 10th, and we'll go from there.
Okay, thank you.
And Mr. Arnold, you may want to consider a 1077 order based on the behavior we're currently seeing. Maybe he's just upset, but this seems a little extreme.
Okay, will do, Your Honor.
Okay. I think that completes everything, and we'll go from
Here on the record in the matter of the City of Wyandotte versus Gregory Benson.
Right, Your Honor.
25256, 241644 A and B, 241.
All right, I think this is DeSanto from yesterday. This one is Zach's fault. I haven't seen it yet, but I'm sure it's good.
1407, 241659, and 241644C. Okay, counsel.
Your Honor, Neil DeBlois here on behalf of Gregory Benson. On all four of these matters, Mr. Benson appears via Zoom from the Wayne County Jail. Mr. Benson, are you able to hear us? Would you please state your name?
Please unmute, sir. In the meantime, appearance for the people, please.
Roger Keeley on behalf of People City of Wyandotte, Your Honor.
Okay. And Mr. Benson, please hit unmute on your device there, please. Mr. Benson, can you hear me? I just asked you to please hit unmute on the device. You see the little button that popped up? Okay. Mr. Benson, can you please grab a deputy, please? Oh, he's handcuffed, so behind his back, so he can't unmute. That's my fault. I didn't know that.
Oops.
Yeah, we're gonna get you back.
Okay, so I'm sorry, Mr. Benson, I didn't realize you were handcuffed. So, Mr. Haley, did you place your appearance on the record?
Gregory Benson.
Okay, thank you, Mr. Benson. All right, and so council, we did have an opportunity to speak in chambers with the prosecutor and yourself, and, council.
Here's your honor, the court will recall and filed a motion to order treatment to restore competency for cases 24-1407, 1644, and 1659, as well as to order a new competency exam 25-256. This motion is based entirely upon the report from the Department of Health and Human Services dated April 17, 2025, that all parties are familiar with. In that, determination was made by that facility that with respect to his competency, that he was presently incompetent, to get the correct term, although he may be, it is possible that he can be brought back, the competency can be restored. Based upon that finding, which we presently dispute, interpretation of the statutes, court rules, and health code, that the court has the ability and the authority to order Mr. Benson into treatment, which is what we're requesting. Further notation that my interpretation of the statute, since this is a misdemeanor, the maximum length of treatment that is permitted is either 15 months or 1/3 of the maximum sentence. There's 3 cases, but each one of them has a maximum sentence of 93 days. Positions that can't be accumulated, so it's at this point, I believe the court can order 31 days of treatment in an effort to restore competency. With respect to the case 25-256, he has not been determined incompetent, and the move here would be to order a new competency evaluation with respect to that case, because at this point, he's not capable of being arraigned. It's my understanding that the court is intending to simply adjourn that matter until we have a direction on the first 3 cases and whether the effort to rehabilitate Mr. Benson is going to be successful. So I don't have any objection to that.
Okay, so what the court's going to do, Mr. Haley, do the people stipulate to the report or the
Yes, Your Honor.
forensic psychiatry?
Yes, Your Honor.
All right, the court is going to then deem Mr. Benson incompetent based upon stipulation of the recommendation from the Center for Forensic Psychiatry. The court is also going to find that Mr. Benson is likely to attain competency, again, based upon the report from CFP. The court is ordering Mr. Benson to receive mental health treatment. We will schedule this matter for a review. So I did the math, and in 31 days, counsel puts us at Tuesday, June 17th. Oh, no, wait, hold on. I lost my math.
Greg has left and he is.
31 days puts us at June 21st. June 22nd. So that's post that. So you could do June 23rd, which is a Monday.
I'm here.
You're here, Mr. Healy is not. We could also do Wednesday, June 25th. But we're past the 31 days
Right.
on both of those days.
So Mr. Haley needs to be present, that would be.
Right. The other option is if you can, I know you're not scheduled for the 18th, but if you can zoom in on the 18th of June, council, then that would be before the 31 days, just like 2 days shy of that.
Momentarily. can do that, zoom in on an 18.
Okay, yes.
Just thinking, keeping her forensic center, see if they're gonna do any follow-up.
Yes, you'd have to do that, yes. And what time works for some 18?
9:15.
All right, 9:15 a.m.
Sorry, Judge, I didn't catch that date.
June 18th at 9:15.
Okay.
Okay, so I'm going to, so I can talk to Stacy about how we have to do what we have to do. What's that? Oh, hi, you need me? Okay, just a minute, we're going to go off here. Okay. Mr. Benson, we're all done with Mr. Benson. Mr. Benson, you're all set. You can let the deputy know that you can go back.
When I go back to court,
June 18th.
where's my charges?
The same as they were. You didn't get any new ones.
What am I charged with?
Public intoxication, alcohol out in public. Those are your charges, sir.
Why can I go home? Why can I go home?
Because the court has ordered, you've been deemed to be not competent, sir, and the court's ordered you to receive mental health treatment.
Where's mental health treatment?
Well, sir, I apologize, but I can't go into all of that right this moment, but there's a doctor there that can go into more detail with you. So you're gonna be back on June 18th. Hopefully you can start the competency.
What's competency?
Where you understand all of the proceedings and that your behavior is not appropriate.
Is that like selling cocaine in Detroit?
No, not even close.
Oh, sir. Good. I'm ready to go back up. Yes, sir. Take down Benson, Rich. Take down Benson back to Cleveland. Take down Benson back. Take down Benson back. They killed my brother. Fuck Michael Miles, punk. Fuck the facts and all. Fuck you too, bitch. Put your contacts on and put the gun up your ass, bitch. Up your ass.
Keep this message down, please.
Yeah.
Ready, Greg?
Yes, sir.
All right, man.
Oh, bitch, what the fuck? You fuck the coat that up your ass. Take that green.
Deputy, just so you're aware,
That's up your ass. Take that up, though, man. Take that back. Put that match and pass your ass. Fuck that coat that the coppers in red blood on the coat that. Could it help me, sir? I'm over by this one.
Yeah,
just so you're aware, Mr. Benson was sitting in there,
I see.
so you may want to get adjusted. Thank you.
Thank you.
Well, that went well. Honestly, I got partway through that clip. I'm like, why are we doing this? Although he was maniacal before that low talking, not really responding thing. You could tell there was a boil underneath. Well, we had some crazies on this one. We had some crazies. It was good times. Thank you again. I see Alyssa has checked in from her undisclosed location. And Zach over at Law Nerds Unite, thank you for hooking me up. I've been running around doing your European things. It's good times over here. It's good times. It feels so good to have Wi-Fi back. It really does. Thanks for coming out. I'll see you soon.